Judiciary.
Well, let me see. Good morning, Chair Taniguchi, Vice Chairs Keith Agaran Rose, and committee members. I am Tom Mick, Head of the Policy and Planning Department for the Judiciary. With me today are Administrative Director Rod Miley, Department Heads Dee Wakabayashi, Susan Gokros, Kevin Thornton, and Dean Secchi. First Circuit Chief Court Administrator, Laurie Akita, and other key judiciary personnel. Today, I will briefly summarize our budget requests for the upcoming supplemental budget year. I have a handout which I believe has been uploaded on your computer that also summarizes these requests, in which in a few minutes I will briefly discuss. Please let me know if it is not on your computer and if you need a copy of the handout, as we brought some extras. But before I get to that, I would like to mention something else. As you know, the mission of the judiciary is to adjudicate disputes brought before the courts and administer justice efficiently, impartially, and in an accessible manner in accordance with the law. I would like to focus on the word accessible for just a moment. Since the start of Chief Justice Rechtenwald's term a number of years ago, one of his and the judiciary's goals has been to provide the public with greater access to its civil and criminal justice systems. To that end, the National Center for Access to Justice in 2016 ranked Hawaii number 3 overall for making access to justice a reality for all people. It ranked the Hawaii Judiciary number 1 for providing support for people with limited English proficiency, as the judiciary has almost 400 interpreters that provide interpretive services in 45 languages and dialects. And it ranked Hawaii number 5 in its support for self-represented litigants, where more than 3,100 litigants were assisted by volunteer attorneys in self-help centers during the first 10 months of 2017. Technologically, access to justice has been enhanced through, one, its website, voted the number 1 court website in the National Association for Court Management's Top 10 Court Technology Solution Awards. 2, through the launching in January 2017 of the Hawaii Courts free mobile app, which contains a lot of useful information. And number 3, through working with the Legal Aid Society to develop interactive software to help the public to complete certain civil legal forms. Specialty courts and programs also provide another aspect of access to justice, with the establishment of such programs as the Veterans Treatment Court, the Truancy Court, and the Steps to Avoid Eviction program in recent years. Also in January 2017, with grant and subsequent legislative funding, the Judiciary, in collaboration with the Public Defender's Office and the Honolulu Prosecuting Attorney, established the Community Outreach Court, which targets nonviolent offenders who are primarily homeless and face problems in obtaining basic services and necessities such as food and shelter. Court sessions are held twice a month in downtown Honolulu and will expand to once a month in Waiua as well. During the first year of operation, 57 persons have participated in this program. 601 cases have been cleared from court dockets, and defendants have served some 676 community service hours rather than face jail or fines that would be unlikely to be paid. Okay, now to our budget. Our general fund supplemental budget request is for 30.5 new permanent positions, which is less than 1%, and additional funding of $1.57 million in fiscal year 19, which is less than 1% of the judiciary's current budget base. And I did notice yesterday that the Council of Revenues has increased their percentage of growth, so there's an extra $13 million, so maybe we could get some of that as well. Anyway, it's okay. 12 of these positions are for no-cost, temporary to permanent position conversions for the judiciary's very successful HOPE and ISIS programs, as funding has previously been provided by the legislature for these positions. Our general fund supplemental budget requests primarily relate to two areas: essential staffing for court and administrative operations and client services. The need for additional essential staffing is a major concern for the judiciary, especially as workload and the number of pro se litigants continue to increase and require the attention of judges and staff. Specifically, First Circuit is requesting only funding for district family court judge and related staff positions, and Second and Fifth Circuits are requesting funding and positions for an additional district court judge and district family court judge, respectively, along with staffing. This would help to address increased workload, case complexities, and delays in scheduling and hearing cases, and also to spend the needed time with self-litigants. In First Circuit's case, the 2007 legislature provided these positions prior to the opening of the new courthouse in Kapolei. That's why only funding is needed for that request. For Second Circuit, the last district court judge was added in 1982, and the population has more than doubled since then from the 77,000 back then. Further, since 2011, while the population on Maui increased by about 10%, new traffic filings have increased by 30%, and new criminal filings by 16%. For Fifth Circuit, there is just one family court judge who was responsible for almost 1,800 new family court filings in fiscal year 17, as compared to an average 1,200 such filings per family court judge at Second Circuit and 1,300 such filings per family court judge in Third Circuit. Overall family court caseload for the Fifth Circuit was much higher in fiscal years 2017, as some 4,486 cases, as they had some 4,486 cases compared to the Second Circuit at 1,837 cases per judge, and Third Circuit at 2,918 cases per judge. For Third Circuit, 2 court bailiff positions are being requested. One for the family court in Hilo, where they have 1 bailiff for 2 family court judges, and 1 for the South Kohala area, which either must rely on clerks to perform bailiff duties or on a bailiff from Kona traveling more than 50 miles round trip. The ICA, or Intermediate Court of Appeals, is requesting an additional position to cover increased ICA workload, resulting from a 2006 change to the appellate system, in that almost all appeals and related motions are filed with and resolved by the ICA rather than the Supreme Court. Since 2006, the ICA's caseload for appeals has almost doubled, and for motions has increased by more than 10 times to more than 2,500 procedural and substantive motions. For client services, in addition to the previously mentioned requests regarding positions conversions for HOPE and ISIS programs, Second Circuit has 2 requests. Specifically, it is requesting 3 additional probation officer positions to significantly reduce probation officer caseload in its pre-sentence investigation, domestic violence, and special services units to a more manageable size. and also additional purchase of service contract funding for the Maui Molokai Drug Court to sustain treatment services at current levels and possibly expand the number of clientele served. The Judiciary has two other general fund requests. One for a part-time janitorial position in Lahaina and one for two janitorial positions, a facilities maintenance position, and a building maintenance worker in Kona. The janitorial positions in Lahaina and Kona are in response to the Hawaii Supreme Court Kono versus County of Hawaii ruling regarding privatization of jobs customarily and historically provided by civil servants. While the two other positions for Kona are for March 2019, some 6 months in advance of the opening of the new Kona Court Complex in late summer 2019, so that they can familiarize themselves with and receive on-site training from the specialized contractors on the building and its new operating and mechanical systems. For Capital Improvement Project, or CIP funding, the Judiciary has requested an additional $18.9 million in fiscal year 19 for various projects at our facilities statewide. Our top priority CIP funding is for $5.8 million for FF&E, or furniture, fixtures, and equipment for our new Kona Judiciary Complex. Construction of the new courthouse is currently ongoing, with the project on schedule for opening in late summer 2019. So it is imperative that the procurement process for the new FF&E begin early in fiscal year 19. Another $10.1 million in CIP funding is being requested for fiscal year 19 to address certain critical needs, some of which relate to the health and safety of judiciary employees as well as the public. Specifically, the Judiciary is requesting $9 million for the Circuit Court building on Oahu to upgrade and modernize fire alarm systems and elevators, both of which are more than 30 years old, are tied into each other, and which continue to malfunction with greater frequency. And another $1.1 million for the Kauai Courthouse in the Fifth Circuit to re-roof and repair leaks and related damages. Lastly, CIP lump sum funding of $3 million is being requested so that we can address both continuing and emergent building issues. That concludes my presentation. Thank you for the opportunity to provide you with a briefing today regarding our supplemental budget request.
Thank you. Members, any questions? Senator Rose.
Thanks. So I was at a conference a few weeks ago up in San Diego where we were discussing the HOPE program, or the HOPE, I don't know exactly what the technical term for it is.
High opportunity, whatever, yeah.
Yeah.
I know what you mean. Yeah.
And the person said to me with some sadness that, it's too bad that didn't work. And I was like, well, my understanding is, Judge Alm got all kinds of awards for it and it was working quite well. And because of that encounter, I was curious what you believe is the status of HOPE right now. Judge Alm has moved on, if I remember correctly.
The HOPE program is still a continuing program, ongoing. I think it has some 2,600 offenders within that program right now. And I don't know, Laurie, is there any more information than that, Laurie Akita?
Oh, hi, Tom.
Yeah.
Yeah, the program is still.
Come on, please.
I think Cheryl. Yeah.
This is Laurie Akita, Chief Court.
Good morning, everyone.
Morning.
And Cheryl Marlowe.
I have Cheryl Marlowe, our Deputy Chief Court Administrator in charge of Client Services Division. Hi. So our program is still on. It still continues. We had a recent transition recently where Judge Edwin Messino has been appointed to the Hope program, and also Judge Kubo handles selected Hope cases, approximately 400 within his division, but it's still going strong within the First Circuit.
Okay, so, but it's your belief that it's working fine? I mean, you know, working is all depends on how you define working, so what do you believe it's accomplishing at this point?
I think it still continues to accomplish the goals and objectives that Judge had set forth when he instituted the program within the circuit court. So I'm not sure with regard to what that person had mentioned, if there's anything that...
What were the original goals?
The original, I'm going to turn it over to Cheryl. Okay, thanks.
Thanks.
Good morning.
Morning.
Primarily, swift and certain consequences was the primary theme, I think, with Hope. It provided the venue to work directly with offenders to get them expeditiously into treatment and provide the necessary, oversight to kind of redirect their paths, if you will.
So swift and certain, I mean, my understanding is the consequences are swift and certain, or at least they were initially, and I'll take your word for it that it's still working that way. But does swift and certain actually work? I mean, do people respond to that the way that we want them to respond?
Well, as you know, there are high caseloads in probation. And I think the goal with Hope was to really be able to, segregate and work with a population that was identified as high risk. And so our orientation with probation is to really to put our resources into the higher risk population. And so Hope afforded us that opportunity to really focus on those high-risk individuals for the safety and protection of our community as well. So by putting our focus, that's really putting our resources in the right place to have an impact with those high-risk individuals. And that's what Hope was targeted at, was to work more closely with those individuals that we could identify that were high risk for drugs.
And as far as you can, do you have some metrics to determine whether that's happening?
Well, we've been following in terms of recidivism. The larger focus was the Interagency Council on Intermediate Sanctions, which we have seen a declining recidivism rate. And our initial goal was about a 30% reduction in a 5-year period. That 5-year period has now elapsed, and we're running around about a 24% reduction, presently, which is pretty good overall. And that was including public safety as well. So this was a partnership for us to really focus on recidivism reduction. So that's one way we track our success. And so we've been on a really a good continuing decline where recidivism is concerned. So that's one measurement. But your question was more specific to Hope. And, I can really say that with Hope, we've been given the opportunity to really segregate that high-risk population and work with them. And when I talk about swift and certain consequences, specifically, that has allowed us to work with the individual immediately and return them for sanctions. So if we do see that there has been an infraction, there's various ways of dealing with that population by sending them to stints of incarceration to try to bring them back in line and to work with the individual. There's also very close monitoring. There's random drug testing done so that we can see their progress and immediately redirect them and get them into treatment if necessary. So that's kind of the orientation that we were able to drill down more with that population.
So, but you think that's working with that population as well? I mean, the recidivism rate you mentioned, that's the overall recidivism rate, or
Right.
That's from that particular subset?
Right.
Sorry, bright
Oh,
meaning.
no, it's the overall.
It's
with
overall, but
probation.
do you have the stats on the subset?
I don't. I could check on that for
Okay,
you
I
as far
appreciate
as
it.
specific with Hope.
Okay.
And we could, Tom, present that through. Yeah. Your office.
I did note that there was a 2016 study that examined the supervision outcome and convictions of probationers who began 5 years of probation supervision in 2007. So it's a little bit dated, but anyways, it showed that the proportion of probationers who succeed in hope probation was 57% compared to standard probation of 23%.
Okay.
So that's statistically
Yes.
significant.
Okay, thank you. Thanks, Sheriff.
Senator Revere.
Thank you. Just for clarity on the Kauai roof.
Yes.
There was money appropriated presently, and then you've come back in for more. Can you give us a brief update on how much has been spent, and are you going to come back every year for another $1 million, or?
It's actually a three-phase project. I'll let Joanne speak, because she's our CIP project coordinator, but it's
Thank you.
three-phase. Okay.
Good morning. I'm Joanne Kripane, and I'm CIP Administrator for Judiciary. We've conceived the Kauai roof as a three-phased remediation project. The roof and the leaks at that facility are premature and basically a result, I think, of a perfect storm of problems. There's very severe weather at that location. It's right across from the airport, so it gets a lot of degradation related to fumes from aircraft fuel. We believe there were construction defects that were not caught. And then we've had maintenance problems because the roof is not accessible. The roof is amenable to a three-phase solution because of the way the building is configured. So there are two wings, plus there's kind of a knuckle, and then we've got an outbuilding that are all experiencing these problems. So we were awarded sufficient funding to do phase one, and that is currently in design.
That's in the 18 budget. The 1.3 million was the phase one? Or whatever was just posted up there?
Yes.
Yeah.
And then, so now we're asking for phase two, and we do anticipate to ask for a third phase.
And how much will that third phase be?
I have to check just a moment, if you don't mind.
And how old is the building?
It's closing in on 15 years.
And you're saying that the fumes from the airport are wreaking havoc on the roof? Are all the buildings in the area suffering similarly?
Among other things. We believe that that's contributing. It's a tremendous corrosion problem, and I think that
So if we were looking at any other buildings in the vicinity, they would all have similar corrosion defects?
not necessarily, because it's really a mix of four different sort of geneses of the
Okay.
problems, because it's not just fumes, it's not just weather, there's workmanship issues.
And is there any recourse for the guys that built the roof? You go back and get them for shoddy work?
We've discussed that with DAGS, and I think that they believe that we're beyond.
Are the people who built the roof in line to help repair the roof? Or is it different
It has not
contractors?
gone out to bid yet.
Is there any
So,
concern of that? That the same company would be back up there?
certainly, but we are not exactly in
And
control
okay,
of
thank you.
that.
And then the third, last question, is what is that third
1,300.
ask?
Or 1.3 million.
1.3 million.
1.3.
So it'll be nearly 4 million, 3.7 or so.
3.4 is what we're looking for altogether.
Okay,
No, I'm sorry, 3.9.
okay, thank you. Thank you, Chair.
No question? Senator Kim.
Thank you. Good morning.
Good morning.
What percentages of the cases in district court is landlord-tenant code?
Landlord-tenant, I'm not sure.
or relates to the landlord-tenant code?
I'm not sure anybody here would know that specifically, and would have to get back to you, I think. Yeah, because
Okay, because I recently had an experience last year of being in the landlord-tenant code. I think Mr. Miley familiar with that. And it seemed as though and I had to go back several times, mind you, and every time the docket appeared that it was like 90% of all the cases seemed that day were landlord-tenant code. And so one of the questions I asked back then is whether or not the judiciary would look at doing a landlord-tenant code court or do something, because it appears that there's so many issues and they constantly make you come back. You show up initially and the judge says, well, do you agree? No? Okay, come back. Then you go back and it's pretrial. And then if you're lucky, you'll get a mediator, but if not, then you come back for the trial. Then you got to come back for the damages, and then you got to, or for the writ. And then you follow the code, the landlord-tenant code, which tends to be in favor of the tenants, which is fine, but you follow all of that, and you give the notice, and you go to court, and then the judge arbitrarily gives them even more time. So, you give the 60-day notice, by the time you get your court date, and you go to court, and they make you come back, and they make you come back, and then finally when you get to the writ, then the judge arbitrarily gives them another 30 days or to come back. So in the meantime, I understand that I learned that during this whole process, that there are people out there who know this system, and they rent a unit, and they say, oh, the check, the security deposit is coming tomorrow, or the rent, my check's in the mail, and they don't pay it, and they get to live for free for 90 days, because by the time they go through the court case, and then when you try to collect, you can't collect. Because you have to garnish, you got to garnish their wages or garnish something.
I empathize with you because I've been through some of this stuff just like you, and I don't know what the statistics are, but we can get.
So how do we fix it? How do we fix that? Because I'm all in favor of giving the tenants all the rights that they have in the code, but when you follow everything in the code, then the courts need to somehow follow that as well, because you're at their mercy at that point. And then, once you give the eviction notice, and if they don't move out, then you got to call the sheriff, and you have to pay for all this stuff. You got to call the sheriff, and then if they take them out, and if they have things in the unit, then you have to store it. And you have to pay to store it. And you have to store it for, I think, 30 days. The law says you have to store it for 30 days. So you have to pay for that cost. And then you try to get it back, you can't get it back. And then the law says you can get double rents, but they don't award the double rents, and you can't get the double rents if they don't move out when they're supposed to.
You're lucky to get the original rent.
Right,
What's
you're
the
lucky
double
to
rent?
get the original rent, exactly.
Senator, we can
Yes.
reach out and work with you in your office and see what kind of support we might be able to provide.
Okay, I raised these concerns during the confirmation of 3 district court judges this past year. And, one of the questions I asked is, how do we make the courts more user-friendly? Because even for somebody like myself, who's a little bit more familiar, can you imagine the tenant that we had to have evicted? They had to jump to the same hoops. They had to find parking. They had to come back 3-4 times. The husband was on dialysis or on chemo. And so it was a hardship on them as well to go through this process. And so one of the responses was, maybe we should make videos, we should, inform the public what to expect. Well, that's good and well, but all you're saying is that we have all these hoops to jump through, and we just have to teach you guys how to jump through these hoops. Instead of saying, well, maybe we need to streamline the process. How do we streamline the process? How do we clear the dockets? And how do we make it so that, people are having their due process, it goes timely, and at the same time, we're not clogging the courts up by having to come back over and over again. Why? Some of these cases are cut and dry. You know, you have the notice, you have all the evidence, you have all the paperwork, and still they make you come back. They don't rule, they make you come back.
I will follow up with you.
Okay, thank you.
Questions, Senator Feely?
Thank you, Chair. I guess to follow up on what Senator Kim was talking about, the Women's Legislative Caucus did an around the state set of meetings with the judiciary and the State Attorney General, and met with the police departments, prosecutors, public defenders, and advocates on and survivors for domestic violence. And what came up over and over again at those meetings was the restraining order process and how cumbersome it was for users, and they had the exact same complaints. You know, a temporary restraining order would be obtained. In this case, it was from the family court as opposed to district court because it's family or household member. And under the TRO, there would be a set time for the hearing on the restraining order set on the service. And the person seeking the restraining order, the petitioner, would come back during that hearing only to find out, oh, it hasn't been served, so we're going to set another hearing 2 weeks from now. And they may come back a second time or a third time. And so it was a really cumbersome process from the people trying to use the process, but we also found out that it's a really ineffective process from the judiciary standpoint because it's eating up a lot of time. And I have to say, the judges who came to these meetings were wonderful in recognizing this and starting to change their own internal process to be more efficient. So I think that they started to set up additional hearing dates on the Big Island and to start to do some things a little bit differently. But I guess I'd want to encourage the judiciary, you know, since you're coming to us seeking more judicial positions, to really be re-examining your process from the perspective of the consumer, you know, the petitioners or who are coming on in and having to come in over and over again for hearings. It's really a problem on the Big Island where people have to travel so far, on Oahu where they have to go all the way out to Kapolei. And then we heard just a heartbreaking story from a woman on Kauai who's continually taking days off of work to go down to these hearings only to be told you're going to have to come back in 2 weeks because there isn't service. Or for the third time, the respondent has said, oh, I still can't find an attorney, and the judge is giving them, you know, yet another month, 4 months to go find an attorney, as opposed to saying, we need to make a decision. You know, you've had an opportunity, and now let's go forward and make a decision. So it kind of exposed a lot of issues that I think the judiciary can handle administratively. You sit down and put your minds to it with some people, and the answer may be different in the different circuits, depending on how they're set up. But I think it would help the judiciary as well as the people who are utilizing their services.
And we really thank the caucus for having the hearings on the neighbor islands, because that provided us with both the local perspective as well as the systemic things that we are currently working on, including the suggestion of having a notification system that would allow for both notification and perhaps the setting of the subsequent hearing dates. So we are looking into that.
Thank you. Thank you, Chair.
Senator Nguyen.
Thank you. And just to follow up, I noticed that under Judiciary 330 that you have several positions, vacancies, and that it was created a vacancy, it looks like 2017, and you expect to fill it. So there's two positions, the district court clerk and a judicial clerk. So I'm just wondering if hopefully we can speed up if it's related to the family court, or whether it's in Hilo or Kona or Kamuela. If you can follow up, there's two positions that's a vacancy. So it probably will help the judges, the family court judges in this particular cases as well with family court. Because I'm sure, if there's a caseload, that means that the clerks are needed as well. And since there's 2 positions, hopefully it can be filled.
And specifically, the 2 bailiff positions that we're asking for the Big Island,
And one for
Kona,
Hilo and one for
Hilo,
Kona.
would be assisting in the court's administration of case management, including what happens outside the courtroom itself. So those positions would also be helpful.
And in line with that as well, with PSD, with public safety as well, I know that there's been issues with regards to security. And I'm hoping that in the district of South Kohala and Kona, that we look at filling a position of another lieutenant, because there's only 1 lieutenant for the entire island that services the courts as well. And so that's another drawback, because there are quite a bit of issues now that our population on the Big Island has grown, and I'm sure it'll increase again in the next census, that we have gained a lot more than the last census, 25%, which is the largest in the state, and I'm sure it's going to be the same. So hopefully that you can support us in making sure that public safety increases the personnel on the lieutenant's position for South Kohala and Kona. Thank you. Thank you, chairs.
Senator Harimoto.
Thank you, Chair. I just wanted to take this opportunity to thank you for the good work you're doing in these specialty courts. So I'm really glad to hear they're continuing and they're so successful. So my question is, in addition to your budget presentation for this coming fiscal year, as we see the emphasis moving toward these alternatives to incarceration, instead of throwing people in jail and locking them up, I think the burden is going to be more on the judiciary now to do more in the area of specialty courts or whatever is planned. So have you made any estimate as to how that's going to impact the judiciary in terms of operations or budget going forward?
If I could, Senator, we've really listened carefully to the legislature, and some of the things that we understood was that when we created specialty courts in the past, it was based on programs that were being developed in other states, things that seemed to be of value, and we would get grant money, begin the courts, develop an experience with them, and if we believed that they would be appropriate, ask for permanent funding. And there was a time when that was workable. Now we understand that there are restrictions on the kinds of resources that are available, and we can no longer create courts just based on good ideas. So what we're looking at is developing the kinds of courts that leverage the resources in conjunction with other entities. So our community outreach court is an example. These are folks that are also providing services through their own agencies, and this is an opportunity to bring folks together. So we really thank the Office of the Prosecuting Attorney, the public defenders, in helping us to bring these resources to the table. Going forward, as you can tell from our budget, we're as lean as we can be. And we intend to be as respectful to the budget process as we can going forward. So from that standpoint, we're not asking for the kinds of resources that would take away things from providers who we hope to bring to the table as well. So we'll try to keep our side as lean as possible, and with money going on for purchase of service contracts that will actually be of value to us.
Okay, I appreciate that. I'm not an expert in that area, but what I do know is that I think people are finally realizing that it's a lot more cost-effective to do these alternatives to incarceration rather than throwing people in jail. So, I know there's those 2 studies ongoing, which I haven't read through yet. But, I'm just thinking proactively, we're looking at replacing old CCC, and there's a lot of pushback from the public saying, don't spend these millions of dollars on a new prison, spend it on alternatives to incarceration. So I'm just thinking, how can we proactively start moving in that direction rather than being reactive? If this legislature decides, to scale back on the prison, we'll need to balance the other side with more programs. So I think, if we can start.
There are two task forces that are going on as we speak. One for the prison reform and those initiatives, and then there's also the pretrial release task force. And I believe that those committees should be issuing their report soon. So that would be a good place to look for future direction.
Okay, thank you. Thank you, Chair.
Senator Rhodes.
Mr. Mick, you had mentioned that you had, I forget the number, hundreds of interpreters. Do you have interpreters for Hawaiian?
Yeah.
So if someone, as probably everyone here knows, that Hawaiian is one of the two official languages of the state. So if someone comes and asks to do their trial in Hawaiian, is that a right, or is that something that the judge can?
Well, sorry, the judge.
My understanding is that there's not a certification test yet for Hawaiian language interpreters.
Okay.
It is an official language, and in cases where individuals want to present testimony, we have brought in interpreters, usually through the Hawaiian language programs at the University of Hawaii.
Okay, so you can get around the fact that there's no certification for it then?
Yes.
Okay.
And our operational focus for court proceedings is that although there are two official languages, that the business of the state is conducted in English, and when folks want to make a presentation in Hawaiian, we do everything that we can to make sure that we have translators or interpreters available.
So is that statutory, or is that just a decision on the part of?
It's both. I believe that as far as the day-to-day business of the state, English is, I believe, the identified language of doing business, but Hawaiian is a co-official language of the state of Hawaii.
Do you happen to know the site for the HRS site for the business, the English's business?
I can get that to you.
I'd appreciate it. Thank you. Thanks, Chair.
And we did have a task force, a Hawaiian language task force several years back where we had asked for different.
Yeah, I think it was my reso, so, yeah. Thank you.
Any other questions? If not, thank you for coming this morning. Thank you.
Thank you.
And have the Attorney General present his budget. Good morning.
Morning.
Good morning, Chair Dela Cruz, Chair Taniguchi, committee members. Nice to see you all this morning. Thank you for letting us brief you regarding our budget and to answer any questions that you have. The Department of the Attorney General stands ready to support you in your committee responsibilities. To my left, obviously, is Chief Deputy Russell Suzuki. He and Dave Moore, our Administrative Services Manager, they're both here to talk about ATG 100 and to answer any questions that you have here. Also, I think, oh yeah, there's Chris in the back. Over in the back over here, Chris Young is our new Hawaii Criminal Justice Data Center Supervisor. He took over for Leanne Moriyama, who retired at the end of last year after more than 30 years of service. We're very pleased to have him back at the AG's office. He was the first deputy prosecutor at the Honolulu Prosecutor's Office, and I'm very grateful that he was able to come back. He's the right person for that very important data center. And then Yeah, there she is. Okay, she has laryngitis, but she's here to talk about the Child Support Enforcement Agency, or David will speak for her, and that would be ATG 500. I'm just going to take some time to talk about some highlights from 2017, and I'll go through it as quickly as I can. Perhaps the part that's most important just has to do with money, and so I thought I'd talk through some of the consumer fraud settlements that have occurred. There was a $2.5 million settlement for the state of Hawaii that came from Volkswagen, having to do with their fake claims about diesel engines. There was also a $477,000 settlement for Hawaii for Celgene when it encouraged off-label use, $700,000 for some fraudulent practices by EpiPen, $84,000 that we just announced last week having to do with Kmart overbilling on Medicaid practices, as well as some other settlements that we reached for ProVigil in a pay-for-delay case, as well as a mortgage company. Didn't have as much effect in Hawaii as other states, but it was there. So that's a total of $4 million. Some successful defenses that we had in the past year. We had a jury verdict finding defense in favor of the state on a $2 million Riften chair case that was brought against the Department of Education. There was also a $30 million case that DW Inalea Development had brought against the state after the Land Use Commission had reclassified urban to agricultural use. That case was dismissed for a statute of limitations. Probably most notably, the Hawaii Supreme Court came back on a case that's been around for almost a decade. It was the substitute and part-time teachers case, where the teachers were demanding $56 million in back pay. The state had given $14 million already to them, but they were demanding an additional $56 million. The Hawaii Supreme Court found in the state's favor, and so we had that. I won't even make.
Maybe we should just focus on your budget request.
No problem. No problem. I just want to just share that we have several budget requests. We want to just say that probably the one that stands out the most is the state security operations. That's the $2.5 million. And I think the question that's come up that I'll just answer right now is people just say, is that Mauna Kea? Are we talking about security operations for that? And I guess the best answer that I can give for that is that the state security operations could be for an event like a Mauna Kea protest. It could be for any episode of mass violence or civil unrest or any event that involves official state government leaders or national leaders. And really the state security operations budget request is one that we made last year. It was denied. It didn't make it into the budget, but it's based upon, not based upon so much our own events that have existed in Hawaii, but really based upon recommendations that have come from the Las Vegas shooting or from the Charlottesville protests that had resulted in a woman being run over by a motor vehicle. So really it was a national best practices recommendation that's been coming from different jurisdictions. In other words, the idea is that, crime overall might actually be, more or less dropping. Not that it's gone, but it might be decreasing. But at the same time, you have these very large events that take place that if there's no contingency fund to take care of that, then that's a problem. And so the experience of state law enforcement in the last few years has been that there's been times when it's not just county law enforcement that's responding to this, but it's state law enforcement. So it's our sheriffs, it's DoCare, it's our investigators at ATG who are responding to that. So that is the reason for the request. I just wanted to say this. The news of my transition has come out, and because of that, I wanted to say that first of all, Chief Deputy Russell Suzuki, he will be the one that'll be taking the lead in advising on all bills that come through from the legislature, and also in answering your questions about the budget through the legislative season. So since he's going to be here through the entire process, then Russell can be able to address that. And then since we're going to enter into the questioning phase, that we'll be able to take your good questions, then I just want to actually just spend this last time just to thank you all. I really am the first to say that it is a blessing and it's an opportunity to be able to be in public service. And I thank you for serving, for serving the community in the way that you did, that you have. I would have to say in the last month, I've probably come to appreciate more than ever the sacrifices and the costs that you have to go through in order to do your job. So I really appreciate you, and thank you for that. So with that, we're ready to answer any questions that you have.
Members, any questions? Senator Rhodes.
So I've gotten several complaints from nonprofits that have purchase and service contracts with the state, not necessarily the AG's office, but the complaint is that there's a statute, I forget, I'm sorry, I should have looked it up before I came over, but there's a statute that says you have to pay within a month once the invoice has been, or 30 days once the invoice has been submitted. And the complaint is that the agencies will come back and say, could you please resubmit an invoice that has a later date so that we don't have to pay you any interest? And that seems illegal. Is that something that you can just like let everybody know that, you would provide legal advice to all the agencies? Can you just tell them that, hey, you can't do that? You have to pay when, if it's legitimate, you have to pay when it's due. And for some, even for some of the bigger agencies, I think it's probably a cash flow issue, but for the smaller ones, it can be really critical.
Senator Rhodes, we
can respond to that. So basically, the law says that after the 30 days, you have to pay interest, the statutory interest that the state has to pay. So we can send out an administrative directive to agencies to make sure that they pay the interest on those delinquent accounts.
Great, thanks. And if you could CC that to me, that would be wonderful.
I will, thank you.
Thank you. Thanks, Chair.
Senator Inouye.
Yes, thank you. Good morning. I think it's still in the morning. Can you brief us if it's settled as well up to now, the Volkswagen settlement? If it's final or it's, yeah, and what's the distribution, or who knows about this Volkswagen settlement? I don't know if the legislature, if we had any information regarding the use, what are you going to use the monies for?
Great.
Or what is the governor expected to use the funds for?
Great. I can get that.
And if you can give it to the chairs, and hopefully, if you don't have it available.
Absolutely. So we put out a news release, 2017-56. It's dated May 31st. I'll get you a hard copy anyway, but it goes through the announcement of the settlement, as well as what it means for consumers and what it means for the state.
What's Hawaii's amount?
2.5.
Okay.
Yeah. So I mean, it was billions of dollars for the entire country.
Exactly. Yeah, I was curious to see what was our portion and what can the monies be used for.
Correct.
Okay.
Well,
All right.
It's in here, and
If you can
share that with you.
give a copy to the chair, they can have distribution made.
Ma'am,
Thank
you
you.
got it. Thank you.
Quick question.
Senator Revere.
Thank you. Thanks. On the payouts in that, every year it seems we get a bill that we pay out so much for a person falling off of a waterfall or crashing a car. Are there any, how would you characterize the current situation? Are there several suits pending? Are there none, or any gigantic ones looming?
Well, what the law requires is that because the legislature controls the budget and the purse strings, that they don't pre-appropriate monies to cover settlements and judgments by the court. So every year we have to submit the claims bill to the legislature for the legislature to fund either judgments entered by the court or settlements that the Attorney General recommends for funding. So those are the cases that you're talking about. So trend-wise, I think, the problem is that the state often is looked to the deep pocket for monies available. So tort litigation, negligence, the state is always included often in order to get the deep pocket of the state. But that's the reality of how our state laws are.
Is there a tentative amount for this year's budget?
We can get you the proposed amount, I guess. We haven't formally, Dave, do you know? I'll get you the preliminary amount.
I'm just curious when you normally, I don't know.
Well, we usually submit a preliminary amount at the beginning of the legislature, and we supplement it during the process of the the proceedings at the legislature, and at the final end, the legislature determines when the cutoff date is going to be. And so people that have monies due based on the settlement thing are aware that it's subject to the legislature's appropriation.
Thank you. Thanks, Chair.
Senator Thielen.
Thank you, Chair. I actually have a number of questions on the different requests they have, if that's all right, but I don't mind if you
Go
want
ahead.
to. Okay. So I guess, thank you for coming over here today. I guess I have questions beginning with the first one on the 2.5 or 2.5 million to provide funding for state security operations.
Yes.
And you mentioned some of these fairly large incidents that occurred on the mainland, but this is 2.5 million that would go into the Department of the Attorney General's budget, correct? It's not to add additional DoCare officers or additional state, okay. So 2.5 million is about the budget for DoCare total for, quite a large number of officers. What are you talking about doing with
Right.
it?
So it's not additional staffing, it's overtime, it's travel, it's equipment.
But just for the Attorney General?
No,
Not for the actual?
it's for distribution to all of the state agencies. So it's not just ATG. It'd be ATG would have, if the appropriation were approved, ATG would have the appropriation, but then it would go to just for distribution to the sheriffs or DoCare or the other law enforcement agencies. That was what happened is that when there, at times when there have been large-scale events, so for example,
APEC.
any sort of large event that's going to be
APEC would be
right, APEC or something like that. Oftentimes, that's just not in the budget, and it's definitely not in a state budget. It's county law enforcement sometimes budgets for this, but it's not really.
So are you proposing this go into the base budget and be an annual appropriation?
Yeah, but as a contingency. I mean, there's. Yeah.
So what has been the overtime costs of things that have not been covered by budgets on an annual basis on average over the last 5 years?
That's a good question.
I mean, how did you come up with the 2.5 million?
I think the 2.5 million came from trying to think through, if there was, from a planning purposes, the State Law Enforcement Coalition tried to come up with a budget of what it would take in order to be able to respond to a very large event, hypothetically. And so what they came up with was the 2.5 million.
But now that very large hypothetical event is now being asked on an annual basis, and we don't have fairly large hypothetical events every year. So I guess what I'm throwing back at you guys is maybe you can come back with a justification for what might be needed either to seed an account, so that there's funding there, but what may be needed on an annual basis based on prior expenses.
I think the problem is that these things are so unpredictable. You don't know. One year you may not need that money, but you may need it sometimes in the future.
Right, but that's what I was talking about, is seeding an amount, just so that you have a base amount, but then what would be needed subsequently. So anyway, just my 2 cents.
But we're not asking for more than the 2 point. It's like, this is the amount that we're seeing as a
I was just asking
contingency.
whether this is going to be part of the annual budget each year, and the answer I got back was yes. So is this part of the annual budget each year?
Well, but I think if we haven't expended the money, it'll lapse and we'll ask for reappropriation to keep the money.
But it would come at an opportunity cost where we would then not have 2.5 million to put into other programs.
That is correct.
That is correct. I think the problem is, though, when you do have an emergency and the state needs to have money somewhere available, it's like,
I'm not arguing with you about that. I'm just asking for you folks to think through whether this is going to be an annual amount,
Okay.
and up to you guys to come back to justify that. I think you understand.
gotcha.
Okay.
Gotcha.
Then the other is the $600,000 increase in general funds for the litigation fund budget, to bump it to, I guess, is it 1.4 million now annually to hire outside
Right, to
attorneys?
2 million. No, it's not just for outside attorneys. This is litigation costs, so it's like expert witnesses that the state has to retain. These cases are complicated, and you need to have experts in most cases, so it's not.
What's the department's expenditures been for the litigation costs over the last year?
Okay.
Let me take a shot at that, because I think what we could get for the committee is actually the year over year, like the requests that have been made, like in the last 5 or 6 years by the department, as well as our expenditures. Because I think what happened was, Previously, it was at 2 million, and then 2 years ago or 3, as long as I've been here, it got brought back to 1.4 million. And so when we hit 1.4 million, we actually found we were in a cash flow situation. So that's where we started to ask, well, can we bump it back up to 2 million? As it turned out, when the budget was passed last year, the final budget actually appropriated 5 million to the Department of the Attorney General. We didn't use all of that money, but it was only for 1 year. So that's where we're saying, I think probably the best way to address, Senator, your good question is to get you those numbers. My only concern was it started to become a cash flow issue when we got to the end of the fiscal year. The feedback I'd be getting is that we're starting to put off paying some of our experts or paying things like that.
Yeah, so if you could let us know what the annual expenditures have been for the department for the last couple years on expert witnesses and outside counsel for litigation, I'd appreciate it. And also, just because I've been getting a lot of questions from constituents and I don't have the answer, if you could let us know specifically the costs for the immigration cases, contesting those.
Sure.
And Chair, if you don't mind, I did have a couple other.
I think we have the expenditures, but we're trying to find the page.
Okay.
Yeah, sorry, I was having trouble finding it because it was mushed with Judiciary. The Internet Crimes Against Children, there's a request to change it from federal funding to state funding. Are we losing federal funding for Internet Crimes Against Children?
Never had any.
Well, I think it's up there, table D.
Table D.
What's 278 on the master?
278.
But it's the table for expenditure.
Yeah, so it just says it's general funds to convert Internet Crimes Against Children staff from federal to general funds. So just I was concerned whether we're losing federal funds.
The federal funds are intended to be used to train and provide operational expenses, not to cover salaries. We've been using it to also cover salaries over the past few years, and the feds have been putting pressure on us to convert the people to general funds.
Are the federal funds expected to be flat, increase, decrease? What?
Flat.
Okay. And then the increase in the special fund ceiling?
That comes from the fines that the legislature imposed a couple of years ago. And right now that ceiling's $10,000. And we're just starting to collect the monies. And we hadn't asked for an increase because there was some confusion initially. But now we're probably going to collect around $25,000 this year, I think. And the ceiling is currently 10.
Right, okay. And then you folks utilize those funds for?
ICAC operations.
Okay.
Strictly ICAC.
So if we were to make this change, would you be able to increase the, investigations and hopefully prosecutions for the Internet Crimes Against Children?
Yes.
So that would give another about $230,000 for you folks to be expending on
230.
But if you were able to switch the staff salaries to general funds, then you would then use those federal funds for the search.
For the operations of the unit, correct.
Okay, yeah. And then I had another question on the police board. So there's a budget request for the police review board based on Act 161 that was passed out of the legislature in 2016. The state recently received a lawsuit, didn't it, for the hiring of a police officer who had been allegedly terminated by the Honolulu Police Department for using his position to abuse a minor, who then, after was hired by the state, is now being, prosecuted for abuse of a minor. So this, I know we had supported an idea of having a statewide board so that the different police departments, and I think we only have 6, right? 2 at the state level and 4 at the county level, would be able to share information like this to avoid these hirings. Does this police review board that's under your jurisdiction have that authority?
This is the board, the purpose of that board that was set up by the legislature, and we've created it, was to simply review fatalities. Okay. So in other words, if it's a fatality that like an officer type shooting or something like that, what the legislature had intended was to create a board that would review those and make a recommendation.
So given this recent litigation that your department is going to be handling, is there going to be a recommendation coming forward from the AG's office to expand the authority of this existing state review board in order to minimize these types of potential liabilities and horrific experiences happening with the citizenry?
Right, I mean, I think that's a great point, Senator. If anything, I think what we are coming in to ask for is a staff member to help that board to be able to call their meetings and function when it happens. But I think that would be something. There has been no officer-based fatality yet, so that's the reason why the board has.
But is the department going to consider, given this litigation that you've now received, is there any internal discussions about doing something, bringing something forward through to the legislature that would help prevent this from happening again in the future?
Not with that board, and so I think that's something that's great that we should consider.
Okay, so you said there's been no police fatalities, but you're asking for a $72,000 increase to support this board that's going to review the lack of fatalities, and as of right now, you have no recommendation, given this other problem with the police departments where the state's facing a potentially fairly large litigation liability. Maybe when you go back and look at answering some of the questions, could you come back to us with some recommendations that you might have that would maybe take this existing board and your budget request and be able to utilize it for some more immediate purpose?
I think the issue that you're talking about probably requires us to consult with the Department of Human Resource Development, because I think that might be like an employment issue throughout the state, regardless of whether it's a police officer or anybody else.
So police officers have additional authorities that citizens don't, and there's a particular liability that's also staring us right in the face with this situation, and probably other ones as well.
Mm-hmm.
Thank you, Chair.
Question?
Okay. And actually, it's a comment, and I'd like a follow-up. A couple of months ago, I put in a call to your office and the call I placed was with regards to comments given to me by people on Kauai, several people on Kauai and Kona, with regards to the incident on Molokai. And the question was, there was a billionaire for a foreign country that was in the waters of Molokai and actually parked there, did go into the harbor. And personnel from the yacht did go on board, on island, and actually what happened was they were chased out and were told to leave the harbor. And the question was, it's a state harbor, and can private citizens use their own authority with doing that? And so comments were made, well, what happens if a yacht would go into Kauai or Honokau Harbor, and, private citizens would chase them out or whatever, use force. And so the question, but I haven't heard yet, so maybe let us know what, are these guys going to be penalized or told whatever, but can private citizens on State Harbor do that kind of actions is the question. And how can it be settled, I guess? Because, we're islands and nobody owns an island
So if you
except
can
for
just
We'll track it.
send a written response to the committee and we can distribute that.
Okay.
Thank you.
Just a couple of quick questions, and then you can add this to your follow-up response. If you can provide the total cost of immigration challenges to the state, because it's not necessarily listed in Table D. So if you can send that
Yes.
in writing.
You got it.
And then can you just verify the 1.25 million in office space? Is that how much you spend in office space?
Are you talking from the leases?
Yeah.
Yeah. Various outside offices based up and around.
So you're not working with DAGs on trying to find
Yes.
you? You are?
Trying to find state space?
Yeah.
Oh, we wish we could. We would much prefer to be in state space, but
Because it comes out to 5,000 a month of lease rent.
yes, and usually when they find, especially with DAGs, they find out it's special funded, that portions are the first big portions they want to move out of state office buildings.
Okay. And then if you can just check with, I guess I saw a line item, 110,000 in your 2016 budget for a software upgrade, but it appears that the money was used for dues and rent instead. So if you can just check on that.
And what would you like to know?
It was on, so was the money used for software upgrade or was it used for dues and rent?
No, we didn't use it for the software upgrade because of the conversion to Microsoft, and the case management system is going to be upgraded into a cloud system. So it seemed fruitless to do that upgrade now until we can integrate the Microsoft system and then go into the cloud with that one. So that upgrade has been delayed at least a year, if not longer.
So what was the money used for?
For
Dues and
dues and rent that we didn't get last session.
And so the Attorney General can just approve moving money around like that?
It was in our operating budget.
Okay. And then how much do you spend on copy machine leases?
Oh,
Is
that-
it 100?
Through that, the whole department? That's on table 14.
Yeah, 191,000
Probably, that sounds like a good number.
for the year. Oh,
I'd have to total up what's ever on that table, sir.
okay. Okay, well, if you can just respond in writing then.
Great, thank you, sir.
Any questions?
Chair, can I follow up? I just took a look at that Table D that was in there, and that's just all the positions in the department. It's not specific to the litigation costs that are for outside counsel or expert witness fees or things like that are outside the department. So I think what's being asked for is money for the litigation fund for outside counsel, expert
Travel,
witnesses, and
expert
yeah,
witnesses.
travel for
Okay.
these types of
So
cases.
if you can send that, and we'll try to send a memo asking so that it's in writing, so you can follow up with the committee.
Thank you.
Senator Kim.
Hi, good morning, thank you. Just again, follow up. So on the immigration litigation, what was the cost?
So 150,000 for the Hogan Levels DC firm, and then basically it was travel for existing, how do I say it? Travel for our deputies to go to the Ninth Circuit arguments. So there have been 3 Ninth Circuit arguments. So each one of those were like $3,000. So basically it was an extra $10,000. So 150 plus 10. We'll get the exact number for you, but I mean, I already know it's essentially about 160.
Okay, but it costs more than that though, right, to fight the cases?
Well, I am sure that the outside law firm, if they were to tell us what they actually would have billed for this, it would have been extremely high. It would not be $150,000.
So is that a gift to the state? Or, I mean, how does that work?
No, it's contracted with them that if they are, the work that they were going to do was going to be capped at $150,000.
So they represented us in the courts for $150,000, but actually cost them more than that?
If they, I'm sure that if they had contracted for what they were going to be billing for, it would have been higher.
So, well, I mean, that raises an issue because wouldn't that then be some benefit to the state in some manner? So if I contracted with a company to provide something for my office and it really cost $10,000, but I only paid them $1,000, So wouldn't that extra amount be somehow, not afforded to that same benefit afforded to the general public with just deans and ethics, or that it becomes some benefit or cost to the state or benefit to the
I
state?
guess I see it more as, parties coming to an agreement at the time that we retain them, that this is what they were going to do. They could have always said, we're going to withdraw because we don't like how this contract is working out for us.
Okay, I think we need to get a little bit more on that. It seems like unusual. But in any event, we receive federal funds, like for the Child Support Enforcement Agency. 66% of that is federal funding,
66%.
is of
federal.
our Child Support Enforcement Agency, comes from the federal government?
Correct.
Is that, now, is this based on a formula, or is it just discretionary?
It's for every dollar. It's for every dollar you spend, you get $2.
Yeah, it's just what the Fed, every dollar we spend, we get 66 cents from them. That's by their agreement.
Yeah, is that based on a formula? Every state gets that, or is it just a discretionary amount? It can change at any whim, or
All states get that. Yeah, all states get that.
all states get the same amount? Okay, that's good to know. As far as your cases, your litigation cases, how many cases do you have that's pending? And for how long has some of these cases been pending? Do you have that? I mean, what's the longest case you have that's pending and it's not been resolved?
Well, like probably the Kalima case,
I'm sorry?
Hawaiian Homelands Claims case, because that's a mix of administrative proceedings plus court proceedings, and it's...
And how long has that case been approximately?
you know,
How much?
decades.
Decades, okay.
27 years, they said.
And what's kind of the next longest case you can think of?
What's,
Next longest case?
that's
For-
probably the long one. I mean, the Felix consent decree was a long case in previous years.
No, I mean,
but-
now,
Right,
what's pending?
so-
Can you guys provide a list of the cases and how long some of them has been pending?
The open cases.
Yeah, your open cases. So of the cases that come into the Attorney General, how many actually go to court? How many actually you
You
folks
mean go to
actually
trial?
go to trial? Yeah, you folks go to trial.
I guess we probably have to give you, there are different types of cases. Most of the courts try to do a settlement process before actual trial goes on, so we're forced or required to go to the mediation or, try to resolve cases. But that failing, then we do go to trial unless we settle it. And if we settle, we do a settlement agreement and we present the claim to the legislature for review
Right,
and funding.
because there's a lot of cases that you guys choose to settle, right?
Correct.
I mean, so I just want to get a
I
sense.
think if you were to ask the judiciary for statistics, they would probably say that probably less than 10% goes to trial. I mean, it depends, if you're talking about civil litigation, a majority of the cases are settled.
But then we have criminal trials, we also have all the administrative
Okay, yeah, if you
proceedings.
can provide that data, I think that's important data, because I hear it a lot of times from the public and from the law community that, government just go in and settle everything because they don't want to go to trial, or they don't have
think
the
that's
personnel to
correct,
go to
but-
trial. Well, that's why I'm wanting the data. So if you guys can provide the data to us, and I think you would want to have that data and keep that data and see what the trend is, right, as to how many cases actually go to trial and how many cases then what's the result of some of those cases. So maybe you can provide that data too. So the cases that do go to trial, how many do we actually win on those cases? The other question I have, and I've asked this before in the past, is what's the status of our 89-day hires?
We have, We can get you the new list. I think we've improved in the number of persons that we've been able to bring on permanently. I think you're asking exactly about the investigators. More
Well, I think all,
specifically,
yes,
or
but all of them. Can you give us?
So I think we can get you, I think we've shown improvement in that area, and I think we can
Okay,
get that for you.
if you're saying you improved, then you should know what the numbers are. What is it? How many 89-day hires do we actually have? Do you actually have?
Currently, we have 21 and a half.
21 and a half total, the whole department?
Yeah, yes.
And of that 21 and a half, they're all investigators?
No, ma'am. That's it. Looks like about 6 or 7 are not investigators.
Okay, and what's the longest 89-day hire on there?
15 terms. 15 terms,
15 terms?
quarters,
15 89-day terms?
quarters, yes.
And is there a move to fix that? Because 89-day hires are supposed to be temporary, right?
Correct, and we've been improving in the statistics. I think if we look at last year's budget, that number was probably double the number of 89-day hires.
But 15 terms, I mean, why would you hire somebody 15 times? That's years. How many years does that calculate to?
Divided by 4, so 4 years.
4 years.
Yeah,
For an
Yes.
89-day hire, 4 years, I mean.
it's difficult finding people to take these positions. Qualified people, we've gone in multiple times in interviews, and we rarely find people that are qualified and able to do the duties.
So you go to retired law enforcement people?
In many cases,
Most
yes.
cases on that. Okay, let's see. Thank you, Mr. Chair. I might have another question, but.
I just have a follow-up, Doug. You know, and you were at the city, and I think Senator Kim
Yeah.
remembers this too. The Corp Council would come to the City Council to explain the different cases, the settlement amounts, and then they would have a closed-door discussion as to if the legislative body should approve those cases or those settlements or not. What process do we have here at the state?
We have an open meeting. I'd love that. I mean, if we had some sort of attorney-client discussion, I feel like what happens often is that the only time that we present our settlement and claims is when we present our settlement and claims bill. I know exactly what you're talking about is Corp Counsel will go into some sort of, executive session and talk about that. So,
Well,
I
you
think it would, because we all know, kind of last year, there were some problems with some of our
Yeah,
our
so-
settlements. I'd love to have that. I mean, well, I won't be here. But
Well, some members have asked if we could have something similar. I'm not quite sure if it's going to be exactly the same. And we would have to work that out, I think, between Judiciary and WAM. But, and in fact, Senator Haramoto probably remembers that too. So it was, I think some of the members want more information before we just approve the settlement amount. So if you can think about that, and maybe we can start doing that this session before we finalize the settlement. If you can get back to us on that. Any questions? Any last minute? Okay, if not, thank you for coming today. This info briefing is adjourned.